Mr. Brockler, do you have anything?
I do, Your Honor. Something I guess I'd ask the court to consider over its lunch break as well. Tomorrow we anticipate calling one of the state-appointed psychiatrists to the stand. I've spoken with Mr. King about the method that I'd like to do in terms of presenting the videotape statements that he took over 22 hours. And we have I guess Mr. King has a proposal. I object to the manner in which he wants to go about it, but I wanted to put it in front of the court to consider before we get to tomorrow. And so I guess what I'm teasing up there is, does Mr. King want to?
Well, tell me your proposal first, and then
Probably a good
I'll
idea.
ask what he wants to do.
Judge, we have 22-ish hours of videotaped forensic interview by Dr. Reid. I anticipate playing all of that. It's the only videotape interviews over the course of this entire case. I anticipate playing all of that for the jury. But rather than have them sit and watch videos for the several days it would take to get that evidence out, I had thought to break up the video to ask questions at different breaks that would coincide with the court's typical clock of providing a break at 10:30 and at lunch and then at 3, where I would ask questions about what was significant or learned about that earlier portion. And I shared that with Mr. King. And then Mr. King has a proposal he wanted to offer that I disagreed with.
All right, Mr. King, what's your proposal?
Well, Your Honor, first of all, I would object to the procedure proposed by Mr. Brockler of breaking up the publishing of this exhibit. And I would say, Your Honor, that I see this testimony in this exhibit as fundamentally different than, for example, the videotape that we had of the movie theater, or some of the other evidence where commentary by the detectives who've analyzed the video and whatnot is helpful to the jury in being able to identify, for example, when somebody walks across the screen, or making some observation that may be otherwise difficult for the jury to see. I think that the nature of this evidence, and it's been admitted over our objection, is such that it's testimonial in nature in many ways. And I would object to being able to parse this out piece by piece, and would prefer to have the entirety of the exhibit played for the jury so that they can analyze it for what it is. It's an series of interviews with Mr. Holmes by this doctor. It's contained on videotape. They speak for themselves, and I think that under Rule 611, the court has the ability to determine how evidence is going to be presented. I also have a practical concern, Judge, and that is that in order to effectively cross-examine, then, I may have to go back through and play significant portions of the videotape again with Dr. Reid in order to be able to effectively cross-examine him about the points that Mr. Brockler has brought out in this kind of truncated fashion. So the proposal that I suggested to him, first of all, I would object to the procedure, and I would ask that the exhibit be played from beginning to end for the jury. If the court is going to indulge Mr. Brockler's proposal and consider allowing him to present it in segments interspersed by commentary and testimony by the witness, I would then ask to be allowed to cross-examine in those segments as well, only as to the subjects raised by Mr. Brockler's questions as he questions the witness about that topic or those topics that were part of that segment. My then cross-examination at the end of Mr. Brockler's direct examination would include other topics not included in those. In other words, I wouldn't repeat and have to have cumulative testimony at that point in time. It would allow us to move forward in a more orderly fashion, and it would allow us to address these issues without having to spend too awful much time with this video and this jury. It would be a more efficient, I think, and expeditious way to proceed if the court is going to grant his request. So those are my two positions, Your Honor.
All right, thank you. And Mr. Brockler, you're opposed to both of those proposals?
I am, Your Honor, and I'd say this. I agree that it's different than the kind of factual evidence of a video being played of what's taking place in the lobby as people are fleeing or what we're seeing in the concessions area. I agree with that. But this video isn't 22 hours, 22 consecutive hours of a conversation with the defendant. It, by its very nature and creation, was segmented to provide for different breaks. And the fact that it totals 22 hours doesn't change the fact that it's really an AM and PM session across the course of what amounts to, I think, 5 different days. So it's already segmented. And what takes place in each of those segments facilitates and encourages changes and different follow-up areas that the doctor goes into in these subsequent areas. All I'm asking the court to do is to say, rather than have 3 straight hours of video with follow-up, which I'm happy to do, is to allow us to break it up to coincide more naturally with the court's schedule and breaks. I understand that, I think the court has the discretion to provide for the presentation of evidence that it wants. I agree with that. But, Your Honor, this is our case. This is our portion of this case. And I don't deny Mr. King the ability to conduct the cross-examination that he thinks is the best and most effective for his client when it's time for him to conduct that examination. But what's interesting is, if the court were to deny our ability to break this up, even to match what was the normal recorded sessions, Mr. King would be left doing exactly what he complains about having to do, which is to revisit different video portions that he thinks are important to go over in cross-examination. This is a manner in which we can get this out that we think in our presentation of evidence is the most effective for not a fact witness, for an expert witness. And then Mr. King, of course, would be permitted the opportunity to conduct the cross-examination I know the court would permit him to have.
Okay. All right, let me think about it.